Professor Blackman is a national thought leader on constitutional law in the United States Supreme Court. His work has been quoted during 2 presidential impeachment trials. He's testified before Congress and advises federal and state lawmakers. He regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. He's also a frequent guest on NPR and other syndicated radio programs. He's published commentaries in the New York Times, the Wall Street Journal, and the Washington Post, and other leading national publications. Since 2012, he served as professor of law at the South Texas College of Law in Houston. He is also an adjunct scholar at the Cato Institute. He's authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. He's also written more than a dozen law review articles that have been cited nearly 1,000 times. He was selected by Forbes magazine for 30 under 30 in law and policy. He's also president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. He blogs at Volok Conspiracy and tweets at Josh M. Blackman. And I was going to ask you about your PA connection that you had mentioned, but you've already described that. So I guess we can go ahead and get started on what your thoughts are on the model rule and how it pertains to Pennsylvania and what's going on with that.
Sure. Thank you so much for having me. It's a pleasure to be here. I went to college at Penn State. I clerked for 2 years in the Western District of Pennsylvania, in Johnstown. I spent a lot of time in Pittsburgh. So if I have connections to any other state, it's really Pennsylvania. I have very close fondness to it. I've actually never spoken to Duquesne, which is very strange. I've been to every law school in Philadelphia, I think, all of them. I've been to, I've spoken at State College many times, but never to Pittsburgh or Duquesne. So we got to fix that next year. Hopefully we can have me back on campus, because I have a very close connection to Pittsburgh and be happy to visit there. When it's warm, though, when it's cold, I'm happy to be in Texas. But most of the year, Pittsburgh's beautiful. The topic today involves legal ethics. And we have a cozy group. Have you guys taken professional responsibility yet? This actually will help inform my talk. Have you guys taken it yet? Just raise your hands. No? Okay, then I can make this. Okay, one of you has. Okay, thank you. Okay, well, that will actually make my job a little bit easier. Every state has ethics rules that govern attorneys. And these rules concern a lot of different things. Simple stuff, right? You can't lie to a court. Okay, good rule, right? You can't steal from your client. Very good rule. Don't steal from your client. That's the easiest way to lose your license. If you're putting in a brief to a court and you're aware of some contrary authority, you can't hide it. That's maybe a little bit more difficult, but you have to follow it. And then there's Rule 8.4, right? And 8.4 governs lots of things that aren't clear violations, but you shouldn't do. You can't engage in conduct that's prejudicial to the administration of justice. Well, I don't know what that is, right? But there are a lot of these sort of very broad categories of things that lawyers should not do. Every state has their own ethics code, but there's a model rule, much like the UCC or the restatement, and it's published by the American Bar Association, the ABA. And the ABA puts out these model rules, and the states, in their discretion, can choose to adopt them or not. Generally, when the ABA puts out a model rule, states fall in line pretty quickly. So if you go travel to Ohio or go travel to New York, wherever you go travel, the rules for ethics are going to be similar. Maybe not exactly the same, but they'll be in the same ballpark. The topic today involves a ABA model rule that has not been widely adopted. In fact, it's proved to be somewhat controversial. And it's ABA Model Rule 8.4G. Right, it's kind of a mouthful. Model Rule 8.4G. This rule is not very old. It came out in 2016. And this rule is designed to address a specific type of misconduct. And I'm just going to read it to you so you have it. Under this rule, it is misconduct for an attorney to, quote, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, I'm out of fingers, or socioeconomic status, so 11. And all these types of harassment and discrimination are barred in, quote, conduct related to the practice of law. So just one more time, I'll try to summarize without the lengthy statement of the various classes. You can't engage in harassment or discrimination on one of these bases in conduct related to the practice of law. The phrases harassment and discrimination may be familiar to you. These are concepts that often arise in employment law. So for example, if you have a worker, you can't engage in sexual harassment, right? You can't deny them a promotion because of their race or their religion or their sex or any of these other bases, right? But this rule isn't governing relationships among coworkers, right? People at the same firm, for example. It governs more broadly harassment or discrimination in, here's the key phrase, conduct related to the practice of law, right? So you can't engage in this form of harassment or discrimination in conduct related to the practice of law. And again, it's not just conduct at your own firm. It is not just conduct perhaps in a courtroom or maybe a transaction room or a deposition room. It's broader. And here's how the rule defines conduct related to the practice of law. Representing clients, okay, that seems related to the practice of law. Interacting with witnesses, coworkers, court personnel, lawyers, and others while engaged in the practice of law. I suppose if you're, giving a deposition to a witness, maybe, or you're talking to a court reporter, that seems, something the bar should be interested in. Operating or managing a law firm or law practice. Again, that seems to be something governing your law firm, perhaps. And then there's this last one, and this is the one that's created the most controversy. Participating in bar association, business, or social activities in connection with the practice of law. This is the one that's created the biggest controversy. This rule would apply to social activities connected to the practice of law. Now, you're still in law school, so maybe you don't have familiarity, but you will be required to take what are called CLE, continuing learning education credits. You're going to hate them, but you're going to have to take them every year. And usually CLEs occur either at lunchtime or at dinner. I don't know why, but those are the two times you have them. The lunchtime ones, you go, when we used to be in person, you would go to a conference room, you'd watch a presentation, they would serve lunch. Often with the dinner time ones, they have an important speaker who gives a talk, or there's a debate or something, and they serve a meal, right? So you're sitting at a table with maybe 10 other people watching a CLE presentation. Under what I think is a fair reading of the rule, an attorney who attends one of these bar association dinners or CLE dinner is engaging in conduct related to the practice of law. And if a person sitting at that table makes a comment that they know or reasonably should know, it's reasonableness standard, that is harassment, they have engaged in misconduct. Now, you may not have stopped and think, what does harassment actually mean, right? We're not just talking about, a physical touching, a battery, if you will, from torts, right? We're not even talking about speech of a sexual nature, making a comment about how someone looks or asking someone to engage in certain sexual conduct. The rule defines harassment very broadly, right? The rule defines harassment to basically mean derogatory or demeaning verbal conduct. Again, not physical, just words. Same words coming out of your mouth. Derogatory or demeaning verbal conduct. Now, what does demeaning mean? Well, that word has a pretty big definition. It can mean showing less respect for someone, showing a disrespectful attitude, right? So when you break it down, when you actually look at the various components of this rule, it becomes misconduct to engage in basically speech at a bar function that might be deemed disrespectful. Now, maybe you are more careful than I am, but in my line of work, I often say things people find disrespectful, not because I'm rude, because I talk about topics that are controversial. I'm a law professor. I talk about abortion, talk about same-sex marriage, right? I talk about affirmative action. I talk about a lot of issues, and my viewpoints are not always what people like. If this rule is taken literally, and I try to read rules as they're written, some of the speeches that I give at bar functions could very well give rise to discipline. Texas, well, remember the bar does not have this rule, but other states may. Now, let me take a step back. Now, why is this rule on the books? And I want you to be very, very candid about this up front. There is a problem of harassment in our profession. I'm not going to deny it. Particularly, female attorneys are often treated very poorly by male attorneys. I don't need to convince anyone of that. I think it's a true statement. It's unfortunate. During the drafting of this rule, a number of female attorneys came forward and said that they were being propositioned for sex by a partner at their firm, right? The lawyer said, "Come back up to my hotel room after the deposition," right? Or they would be hitting on them at a Christmas party. You know these stories, right? So I think one of the motivations for this rule was to sort of find a way to discipline or perhaps discourage attorneys from engaging in this behavior, right? If it's your partner or your boss who engage in this relationship, you can file a lawsuit against them under the Civil Rights Act or state civil rights law. But what if it's opposing counsel making these comments to you, right? Or what if it's an attorney you meet at a bar function who starts hitting on you and sort of pushing you to go back to his hotel room, right? He's not in your office. You can't sue under Title VII a random person you met at a bar function, right? That doesn't work. So I think this rule was trying to accomplish was to give attorneys the power to hold accountable other attorneys, even when employment discrimination law doesn't permit that sort of, that sort of action. And I'm actually okay with that, right? I'm not objecting to that part of the rule. I think it's actually well intentioned. And that's why I think they put in this language about social events. I think it's exactly why they put it in. The problem, though, is that they define the phrase harassment, I think, at too broad of a level of generality. I think they sweep in far too much conduct and speech on matters of public concern. And I think this rule risks chilling debate on sensitive social issues. And that's both people who are at the stage talking about these law issues, but also people sitting at the table talking amongst their friends about really sensitive issues of law that people don't always agree on. So at the very beginning of this rule, when it first came out, I was very concerned because I worried that it was well-intentioned, but it could lead to the chilling of speech on matters of public concern in several regards. Since 2016, the law has not fared very well. I'll just give you some numbers. 6 states formally rejected the rule: Arizona, Idaho, Montana, New Hampshire, South Carolina, Tennessee. In 3 states, they put out a comment period, but they never actually acted on it. They just sort of withdrew it. Nevada, Louisiana, Alaska. In three states, there was a comment period that closed, but nothing's been done. And that's D.C., it's not really a state, but D.C., not yet at least. D.C., New Mexico, and Utah. And where I live in Texas, the Attorney General's ruled that the model rule is unconstitutional. Only one state had adopted it in its entirety, which is Vermont. And it did so very quickly. No one even knew about it. It was done very quietly. Shh. The rule's under consideration in New York, which is a big one because New York is one of the biggest legal markets in the country. California has not adopted. That's the other big legal market. 3 states adopted a more narrow version of 8.4. New Hampshire, which again did it very quietly. Maine, which did it very quietly. And my favorite Commonwealth, Pennsylvania. About 3 years ago, Pennsylvania requested comments upon the rule. And they requested comments again. And they requested a third round of comments. And finally, after 3 rounds of comments, they basically adopted 8.4G with some subtle modifications that frankly don't make much of a difference. I won't even mention them. I'll cut to the chase. A lawyer in Philadelphia challenged the constitutionality of the Pennsylvania rule. He works for a group called FIRE, F-I-R-E. Do you know FIRE? You heard of it? It's the Foundation, I guess trying to get this right, the Foundation for Individual Rights and Education. It's a free speech group, and they defend rights of students and faculty to engage in free speech. And one of the lawyers, his name is Zach Greenberg, argued that this rule would chill his speech, that he likes to go to college campuses and talk about very sensitive topics like sexual assault, Title IX, right? And he said, I worry that if I give speeches on these topics, people may deem it to be harassment, right? They may deem it offensive to talk about these issues and actually defend those accused of engaging in these crimes. I'd be traumatizing to use the words of the day. About 4 or 5 months ago, a federal judge in Philadelphia declared the Pennsylvania rule unconstitutional. He actually issued an injunction barring Pennsylvania from enforcing 8.4G. And the court effectively said this is a form of viewpoint discrimination. You may think offensive,ness is a standard you can understand, but it's a viewpoint, right? Say you're allowed to say this, but not that, right? You can take position A in an issue, but not position B. You could defend, let's say, affirmative action, but you perhaps can't criticize it, right? You can defend the Title IX, but you can't criticize it, right? And when you have this sort of thumb on the scale of one-sided debate, the court said there's a viewpoint discrimination, which is a point I have been making for nearly 5 years at this point. So the court enjoined the Pennsylvania rule. At that point, the Pennsylvania bar filed a notice of appeal to the Third Circuit. They're going to defend the rule. And then about a month later, something funny happened. They withdrew their appeal. Pennsylvania withdrew the appeal. They weren't forced to. They could have done it. They had every right to appeal the case, but they chose not to. Why? Right? Why did Pennsylvania withdraw their appeal? No, I don't know. No one told me. I don't know anything. But we can speculate. I think Pennsylvania showed the writing on the wall. The state recognized that this rule has constitutional defects. And I think they tried to go back to the drawing board and perhaps rewrite a new version of the rule without these sorts of defects. And that's significant. I think that's very important. I wish they had just done this in the beginning. We submitted comments years ago. They could have avoided litigation, paying attorney's fees, but that's how they're going to spend your dues. Right? Unfortunately, you're going to be paying dues to the Pennsylvania bar. That will be covering the cost of this litigation. So you're welcome. I'm sorry. But that's what we have to deal with. Now, I think there are ways of making this rule better. And I'm not of the position that just burn the entire thing down and just get rid of it. I think you can improve upon it. And I'll just give you a couple suggestions I think might, actually resonate. One is I think you need to be more precise about what harassment is. A single comment at a bar function should not be enough. In employment law, there's a concept that harassment must be severe and pervasive. It's a phrase you may have heard in employment law. Severe and pervasive. And what that means is, if one guy tells a female coworker, I like how you look, right? That one comment alone will not be harassment. It was an offhand comment. Maybe it was well-intentioned. Perhaps the female coworker didn't appreciate it, but that's not enough for a harassment suit. Now, if a male colleague tells a female employee every day, I really like how you look, every day for like a month, okay, then that maybe gets carried away, right? That becomes pervasive. It's the same thing over and over again, right? That sort of regime, I think, is important here. A single comment at a bar function should not be enough. Now, it's severe and pervasive, and sometimes a one-time comment could be severe enough. Maybe if you do one thing, you make, I'm not even going to try and give you an example. Sorry, not happening on the Zoom call, right? But let's say an employee makes a really blatantly sexist remark and propositions an employee for a coworker for some sexual act. I mean, I'm saying really, really blatant, like really bad. You can just, use your imaginations for a minute. Okay, that was maybe a one-off comment, but that was pretty damn severe. So it's possible that if a one-off comment raises to a certain level, that might be enough. It's hard, though. Usually you need some sort of pattern of conduct. If you were to add severe pervasive to 8.4G, I think it would take care of most of my concerns, right? Because it's not going to be the one offhand comment. It's, oh my God, I can't believe what that guy just said. It was like the most awful thing I've heard. We have to take action. Another way you perhaps can modify or mollify 8.5, mollify me by modifying 8.4G is by having a direction requirement. That if a person makes a comment that's based on one of these protected classes, race, religion, etc., that's be directed at a specific person, right? In other words, if I say, John Doe, shouldn't have gotten into college because of affirmative action. I'm making comment directly because of him. That might be a closer case to find liability. But if I said affirmative action is a bad policy because it perhaps, doesn't judge people based on merit, right? Okay, that's sort of a general statement. If you have a targeting requirement, it makes it more likely to capture the sort of conduct that's about someone, and that is more traditionally what you think of with harassment, not just sort of general talking about an issue. Another proposal is the mens rea. The mens rea of the current rule says whether you know or reasonably should know, right? Know or reasonably should know. That's tricky because I don't know if a reasonable person standard works with, how should I say, young people, right? Because what I think a reasonable person would find offensive is not what most college students think a reasonable person might find offensive. It's very tricky. I mean, I know you do torts, what's a reasonable person with sort of modern people, but sensibilities change very quickly nowadays. And things that I thought were entirely fine to say now are no longer going to be said. Even our language changes on a weekly basis, it seems. Or like 1984 territory. So maybe instead of having a reasonable standard, you have an intentional standard. Did I intend to harass someone? Did I intend to discriminate? And that would also obviate the sort of inadvertent comment that can give rise to liability. Again, if a senior partner tells a female associate, you better come to my hotel room afterwards, that was an intentional act. It doesn't matter what people reasonably should know. It was intentional. And I think that may be severe and pervasive. I'm not sure. Maybe a one-off is not, but depending on what was said, did they have any sort of relationship? There are factors to think about. But again, I think you could reformulate this rule in a few ways to sort of target it. But let me just pull back a little bit more and discuss what is the role of the bar. Now, you're all 1Ls, 2Ls, 3Ls, right? The bar exam is like this scary thing, this exam you have to take in a couple of years, and you're going to just hate it. And, oh, God, it's miserable. But just push through it. You'll be done with it. I don't know. Pennsylvania used to have a very high pass rate. You guys still have a very high pass rate? They used to call it the candy bar back in the day. I don't know if they still call it that because it was so easy. But anyway, just do it.
We moved to the uniform bar exam starting in 2022.
Is that right? We have Texas UBE now. Well, but just do it. Get it over with. It's going to suck. But the bar doesn't go away after you pass the exam. It's stuck with you for life. And so this ever-present force in your legal careers. And, we should start asking ourselves, what exactly is the purpose of the bar? Right? Why does the bar exist? What goals is it serving? Is the purpose of the bar to sort of police all forms of misconduct? Or is the purpose of the bar to police misconduct in the legal profession, right? How far removed is their jurisdiction, right? What is the scope of activity that the bar should be involved in regulated? And I think it's a fair question, right? A lot of critics of 8.4 say it's not even the job of the bar to think about if people are harassing, right? Let that go to employment law. Let that go to stalking law. Let that go to, criminal law, if there's actually a criminal act performed. I'm sympathetic to that view. I'm not persuaded by it, but I'm sympathetic to it. But in my view, if you're actually engaged in a practice of law, I think the bar has some leeway. But if you're merely engaged in conduct related to the practice of law, it's less certain. All right. I'm right about half an hour. I think I've said enough. Let me stop here, but I hope maybe some questions. We have a small group having a discussion maybe. But thank you so much for your attention.
Professor Blackman, thank you so much. My immediate follow-up is, what about Model Rule 8.4 in light of NIFLA? And we're in the Third Circuit, right? And so we are, part of the jurisdiction that had the professional speech, so-called professional speech doctrine. How about the Supreme Court's abrogation of that? And I mean, this certainly looks like it regulates speech. Can you talk about the constitutionality there as well under NIFLA?
Sure. Yeah, very, very good question. So a couple things to keep in mind. The 8.4G rule was drafted back in 2016, and I think there's been actually a shift in the Supreme Court's approach to free speech law in the last 4 or 5 years. So the case that was just mentioned was called NIFLA versus Becerra. I always forget what NIFLA. I think it's the National Institute of Family and Life Advocates, NIFLA. This is one of these so-called crisis pregnancy centers where they have these centers where women can get not abortions. They can get ultrasounds and get other sorts of services to see if they're pregnant, but they are sort of nudged away from getting an abortion. And I'll leave it at that. They will not refer people to an abortion. They will not counsel them. They'll give them a pamphlet for an adoption agency, right? They don't want they don't want an abortion in this case. That's what these groups do. California passed a law that mandated these centers provide information, and this information said the state will provide a taxpayer-funded abortion for you. Right? That's what the information says. It's free, no cost. NIFLA opposed this, saying you can't force us to disclose this information. And this was in a couple ways. One, it was you had to put like a sign on your wall, and two, you had to actually disclose it. That the people working there had to actually disclose it to anyone who walks in. And the court said this was unconstitutional. Now, California defended the rule and said this is professional speech. This is speech for doctors, and they weren't all doctors. They're also medical professionals like nurses and other people. But the state can regulate the information given by medical professionals. And there were, in fact, cases from the circuit courts that said there's a category of speech called professional speech, and the state has greater latitude to regulate professional speech, that it's not going to be subject to a strict scrutiny analysis. It'll be more deferential, almost like commercial speech. The Supreme Court emphatically rejected that, and the court said, there is no separate category of professional speech. This was a Justice Thomas opinion. Now, I'll be honest, I don't know that NIFLA is consistent with past precedent, but it sure as hell settled the issue, right? It clarified that we're not going to carve out different categories for speech. There's some other old cases from the 80s about attorney speech, regulating attorney speech. For example, regulating commercials and advertisements. And the court basically said, well, yeah, those are different because you're trying to stop fraud. We're just going to limit it to that. So the court basically said the case from the 80s involving attorney advertising speech was sort of in a different realm, so don't worry about it. So now we have this NIFLA case which say you can't regulate medical speech differently than you would any other type of speech. And I think that case really killed 8.4G, because we're not even talking now about an attorney giving speech in his law office or in court. It's attorney speaking at a social function. And I don't think you can reconcile that reading of 8.4G with NIFLA. Now, the American Bar Association, the ABA, put out a report last summer saying, oh, no, don't worry about 8.4G. It's perfectly constitutional. Did they cite NIFLA versus Becerra? They did not even cite it. Remember I said one way you get in ethics trouble is by failing to cite relevant authority? Remember that? The ABA didn't even cite a controlling Supreme Court decision. Very sad. I mean, they've really had to bend over backwards and pretend like things are in this fantasy world to defend this rule when there's a Supreme Court precedent. You may not like it. You may think Justice Thomas is wrong. You're allowed to do that, but you have to acknowledge it. They didn't even cite it. So I think at this point, the ABA should throw in the towel and say, okay, we screwed up. Let's write a new rule. Start from scratch. Maybe you can do it right this time, but the current version, I think, is not going anywhere. But really good question.
I was wondering, like, reading the opinion from the Pennsylvania federal court, they didn't get into this, and obviously this hasn't been litigated that much since it's kind of new, but as far as like, I'm curious about what is the context in an education type setting. Obviously, like a law professor is someone who's practicing law under this definition possibly. So, how far would the reach go? Is that a concern that like it would delve into that area, or is that too far removed?
Well, I made this point almost 5 years ago. I'm a law professor, right? I speak at my own law school. I talk to other law schools. I am pretty sure that my speech is related to the practice of law. Why? Well, if you want a law degree in my state, you have to go to law school, right? It's an essential attribute. If CLE credits are related to the practice of law, then so is law school. Now, if my speech as a law professor is governed by 8.4G, Lord help me, because I say things on a regular basis that people find offensive. It's not because, again, I'm not mean. I'm not trying to be a rude professor, but I talk about issues that are very sensitive. Again, abortion, gay rights, immigration, pick whatever issue you want, right? I talk about all these issues. If I can have a student filing bar complaints against me whenever I piss them off, I'm screwed. It's like basically ratemyprofessor.com, but with a bar complaint, right? It's like real. Now, look, the bar is not going to take action against me. They're going to say, okay, this student was obviously annoyed at Professor Black, and they're just going to ignore him. Fine. But I have to deal with it, right? It's stuff I have to deal with. And it's potentially time and money. I have to hire a lawyer to deal with these complaints. Bar complaints can be filed very easily. Law students who are annoyed have a lot of incentives to do this. So I would worry if this was extended to the context of, of law schools, but I think it could be. Okay. What other questions you have? Just jump in. We got a cozy group.
I have a question, I have a comment related to your alternative models
Sure.
For the school, especially the last two, because it reminded me of how it would deal with contextual targeting, right? So I'm reminded very much of Henry II's "Who will rid me of this troublesome priest?" At the end, Thomas Becket still dies, right? So if you have someone, okay, it's not you, X person, should not have gotten in by affirmative action, but if someone tells you, well, I was helped by affirmative action, and you quite obviously in the context go, well, affirmative action helps substandard people get in.
Mm-hmm.
You have plausible deniability there, both on the targeted nature and on the intent. And I'm not sure I want that ambiguity there, because I'm not sure I want the ABA deciding on those cases. And I would wonder how you would incorporate a system, if it should even apply to those types of statements. And if so, how you would want to control them.
Yeah, it's a good question. So, to sort of, let's say they revise the rule along the lines suggested, and you have a very smart person who sort of skirts around the issue by just sort of saying, well, it's not you, it's in general, right? I think, if you want to say intentionality, in general, you can decide intentionality from factors, right? Even if you don't do it, there might be indications that you intend to do it and sort of took like a shortcut of doing it as well. So I think even with an intentionality requirement, you could still get at that speech that it wasn't targeting directly, but you were using like basically euphemism or like a roundabout way. So I think if the the situation you're describing actually happened as you described it, I think you could probably still find liability in that situation. But it's a good question, and I got to look up the Henry II reference. I got to Google that one together. That's a good one though. Thank you though. What other questions you have?
I have a question that kind of ties in with Jordan's. Like, if there is, like that targeted component to the rule, could a third party still report an issue? So, like, let's say someone is repeatedly making a comment at a woman at a bar function, and like it happens all through the night, and another woman is bothered by it and threatened by it, and she reports, not the targeted person. Is that something that?
Yeah, you know what? I mean, I don't think it has to be the victim herself who has filed the complaint. I think it's just whether it was targeted in general. I think someone who observed it could also file the complaint. I think it's not a problem. I mean, just put the position more broadly with legal ethics, right? Let's say there's a person at your firm who is engaging in some unethical conduct, and his partner's like, "Yeah, I know, but I don't want to bother him," right? You have an obligation to report conduct that you think is unethical, right? It's not just, now that I think about it, yeah, let me actually, I think your question is better than you even knew, right? I think you actually have a duty. If you think a lawyer is actually engaged in unethical conduct, it's not just should I, I think you actually have a duty to report it. So yeah, I think it's a good question. If a third party says, "Oh my God, look, this guy's breaking the rules," right? And then the other person's like, "No, I don't want to do anything. I don't want to rock the boat." I think you would actually have a duty to do something about it. Yeah, good question. Yeah, this is a good point just for you all to realize. If you see someone else engaging in conduct that you know is unethical, there's an obligation upon you to report something. Now, that can be done different ways, right? First, you could just talk to the person, like, "Look, I think you did this misconduct. Can you self-report, right? Or can you take care of it? You do something yourself." They say, "Screw it, no." Okay, maybe you talk to their boss, like, "Look, your associate here is engaging in ethical conduct. He did something wrong." You elevate it, and then eventually he's like, "Look, I tried to go with my channels, and you can go to the bar." The legal profession is self-regulating, right? It's kind of weird. We're expected to sort of police ourselves, and that means policing your colleagues, which often means saying that someone you know and like very much screwed up, and that's not a pleasant thing to do, right? No one likes to do that. But I think your comment is well taken. What else?
Professor Blackman, I am curious about the free exercise of religion piece that I think is implicated with Model Rule 8.G, with the associations like the Christian Legal Society, of which I'm a member, but I also think that there are other religious groups of attorneys that hold views that might be discriminatory in the events. And I know your suggested changes address that a little bit, but I'm curious maybe to flesh that out a little bit more and the challenges there. And then the second piece is how those of us that are in these groups can collaborate with the policy makers to fashion a rule. I don't know if anybody in the Christian Legal Society that wants to actively discriminate against someone else, but we have our own views, So I'm curious how we can collaborate with the policymakers to fashion a better rule that serves the interests of regulating the profession and dealing with reprehensible conduct.
Yeah, thanks for the question. So far, I've only talked about freedom of speech. I've not mentioned free exercise of religion. But one of the biggest opponents of this rule has been the Christian Legal Society that you mentioned, and I know many of the people there, and they've been on this for years. Let me make a few points. So, first, when we're talking about free exercise of religion, the law is in the moment at flux, right? We have a case of the court this year called Fulton, which might resolve. Sorry, it's bad pollen today. I have a sneeze. Okay, dance sneeze, good. Fulton, which may resolve the scope of free exercise. So let me just speak more broadly in terms of concerns and not specifically about the Smith test, which I think might be modified soon. The way 8.4G is structured, certain types of speech we privilege over others, right? So if you speak out in favor of gay marriage, you're fine. If you criticize gay marriage, you're in trouble, right? If you speak out in favor of gay rights more broadly, you're fine. But if you're perhaps skeptical of transgender sports issues or pronoun issues, whatever issue you want to pick, right? You're in trouble. So the sorts of issues that routinely face Christians in particular and other people of faith are more likely to be subject to liability. Now, the usual response is, well, yeah, Josh, get with it. Christians are bigoted, right? So get over it, right? That's the usual response I get when I make this point. So let me just address that one briefly. We live in a society that has different views, and even Obergefell recognized that people in good faith can disagree with that decision. I don't know if people believe that anymore, but that's at least what Justice Kennedy said. Perhaps things have changed in the last 5 years. So long as we're willing as a society to tolerate, and I think we should, religious views that go against the sort of mainstream progressive orthodoxy, these rules should not be weaponized. And we should recognize that there's space for the SIA, Christian Legal Society, to have a CLE function where they have someone critical of Obergefell, or they have someone who's skeptical of transgender rights. Agree or disagree, these are views that are had. Maybe in 20 years, these issues disappear, which I think is probably where we're headed, maybe in 10 years, maybe even less. Things move quickly. But I would not want to use a rule of government to sort of squelch very long-standing religious norms that have existed for millennia, whereas Obergefell is like 6 years old. That's where my general response is. But my work mostly focuses on the free speech, not free exercise of religion. Yeah, thank you. Further questions?
I guess I was also wondering, how would this look if it was, like I know you said a student could report a professor or perhaps a Federalist Society speaker. How could this play out with clients? Like if there's a client who comes to a firm and the firm assigns a case to an attorney, and for whatever reason, perhaps religious, the attorney's like, I can't work on this case and be a zealous advocate for this person for like on this issue. Does the rule apply? Like, can a client report an attorney or?
Right. Well, so a couple things. So when you're actually talking about an attorney representation, that is clearly in the practice of law. And, I don't have a strong, perspective on the bar should be able to govern attorney-client relations, right? So that's something which I don't think even most of the people in CLS would argue about. An attorney should be in the practice of law. The harder issue, though, is about accepting or declining representation. And if you read 8.4G, I didn't read the entire thing, but it says in the comments that this rule does not affect your ability to accept, decline, or withdraw from representation, right? So attorneys actually have a lot of discretion over taking a case, right? And I'll give you two examples, right? One, a member of the KKK walks into a law office and says, I'd like you to defend my right to burn a cross on someone's lawn, right? You can turn that person away. You don't have to say, yes, I'll take you, right? Or let's say you retain a client who then turns out to burn a cross on someone's lawn, right? You can say, you know what, I'm gonna drop this case. I don't think I can handle it. And I think most law firms would be okay with that, and most bars would be. Now let me give you the other example, right? Let's say you're a Christian lawyer and the Planned Parenthood walks to your door and says, I want you to represent my right to have challenge from abortion law, right? The general rule is you have the right to turn down that client. Say, you know what, I'm a Christian lawyer. I don't want to represent Planned Parenthood, right? So there's actually a lot of latitude for attorneys to accept, decline, and withdraw representation. So the example you gave is actually a good one. I think the harder example is during the course of the representation, the client learns that the attorney has views on sexuality or affirmative action, whatever issue you want, that the client doesn't like. And that's the hard issue. It's not about withdrawing or declining the representation. It's can they file a bar complaint based on comments the attorney made? And that's where I think 8.4G could come in as written. Good question. Very, very good questions. I know there are not many of you, but you're very on your games. What else you got?
Anyone else? I know you said you had another appointment, right, Professor Blackman?
Yeah, so we can maybe just wrap up for maybe another minute, but I'm happy to take one more question, or we can wrap and call it a day.
So Professor Blackman, maybe I'll expand from the scope a little bit and ask for your advice for folks that are attending a Federalist Society event in law school. What are some things that we can be thinking about, or things that we can do now as law students to enhance our learning on topics like this, places of further study? What are some of your recommendations there, just for ways to continue to learn more and get more involved?
Well, you mentioned where I blog, the Volokh Conspiracy. I'll put the link in the chat. Read this blog on a regular basis. You'll be much better for it, and you can follow my Twitter as well. But definitely check the blogs. Oops, that's not my Twitter. I don't even have my account. That's my Twitter. Check the blogs. Keep up to date. But the Pennsylvania one, which concerns you the most, is dead for at least a couple years. It took them almost 3 years to do this first iteration of the rule, and they got their butts handed to them in court. So it's going to take them some time to try to regroup and find a new rule. So maybe like in 2 more years, we'll have another rule, which will go back to court again. So I think we've done it for a while. Very good questions. All right, thank you all. This was pleasant. I'd love to come back. I love Pittsburgh. Hope we can come visit maybe next year. Okay.
Oh, that sounds good.
All right, guys.
Much.
Take care. Have a wonderful day. Have a wonderful evening.
You too.
Thank
Bye-bye.
you.
Thank you so much.
Thank you so much.
Thank you. Bye-bye.